Hey guys, can you guys hear me? Awesome. I was wondering what was going on. Sorry guys, I'm not an expert like everyone else that has done the streams as often. How are you guys? Thank you guys for coming in. I know Vanessa is an expert and her team are all experts at streaming. So I usually do presentations in person. I'm a lot better in person, but as you guys have maybe seen some of the presentations that I've done for Dreamers Together, I am Adriana. I am a paralegal here in New Jersey. I have been working in immigration law for a few years, and specifically with in the state and with a nonprofit. Um, for the past couple of years, but I have been around the Dreamers Together for a while. So I'm a DACA recipient myself, and I do presentations on immigration all the time. Today, though, no, everybody is really good at streaming, let me tell you. I've seen some of the lives. Um, but today, specifically, we're going to be talking about removal of conditions. It's a really important topic, especially for those of you who have done adjustment of status and are living the green life, but have gotten a 2 year green card. A lot of people don't know about um, the conditional the conditions on of a green card and how they have to be removed after having it for what, a year, 9 months. So it's really important for you guys to know some of this information. So if you know anyone who has their green card but only got it for 2 years, it would be good for them to watch this and kind of learn that they can get their removals done by themselves if it's a straightforward case, or at the very least know the basics. um, so before anything, I always do a disclaimer on any presentation I do. Obviously, at Dreamers Together, any information that you get is for general education purposes only, because obviously in immigration, each case and the facts of a case are different. We cannot give general legal advice in one presentation because everyone has a different case. There could be different scenarios, so just be careful. Um, Obviously, immigration law changes constantly. So today, all of this applies, but things change. And so if you see this in a year, it might not be the same. But for now, this is what the removal of conditions information is. So just know that if you have a case that you feel is complicated, or that you have, questions about your specific case because there's something, either there's a criminal record of some sort or anything that you feel makes your case complex, find yourself an attorney, but make sure he's knowledgeable in immigration, not just any attorney. There are some attorneys that aren't very knowledgeable in what they do, and that's putting it in a nice way. But just be careful. Be careful who you go to, and be careful. You don't want to overpay for something that you don't end up getting. So that's just a disclaimer that I like to say. Again, welcome. And so today's, uh, you know, presentation is on removal conditions, the I-751. What is that? A lot of people don't know what removal of conditions means, what it actually entails. The process of removal of conditions is for all individuals that did adjustment of status through marriage or were petitioned, but got a 2 year green card. Um, a 2 year green card means that they got a conditional green card, right? The reason there's this process is so that the government, through this process, weed out anyone who got adjustment by committing marriage fraud. So the marriage isn't real and they were able to get adjustment. This removal of conditions, this process kind of weeds out those marriages, or at least attempts to weed out those marriages. It's again, established for people who have acquired lawful permanent residence. So they're living, the green life, but they really aren't supposed to. Um, and so you have this process, which is the conditional green card process, right? And you have to go through the 751 to remove those conditions. If you have a 2-year green card, you have to remove conditions. You cannot file, an I-90 to renew your green card. There's no such thing, because you have to remove those conditions and then get, your 10-year green card. Obviously, to do this process, you are going to have to submit proofs like in any other immigration process. So be aware that you will need to provide a bunch of proofs. A lot of people think that once you have your green card, even if it's a 2-year green card, um, that's it. You don't have to do anything. It's over. You're out living your best life with your 2-year green card. Like, no, that's not the case. If you have a 2-year green card, you still have to keep record of your marriage and make sure that you keep proofs. You're holding on to proofs throughout the year, 9 months after your green card got approved, because these conditions have to be removed. And for that, you are going to need to prove that your marriage was real. Again, since you've already done it the first time, but this time you're going to kind of have to reiterate the fact that it's real. Um, Again, what is a conditional green card? So there are two types of groups that get conditional green cards. This specifically applies, at least in this presentation, in the context of those people, again, that got through marriage. So all of you guys that did your AP were sponsored through marriage, but you became a permanent resident before your 2-year anniversary of your marriage. And so that's why you got a conditional green card. uh, you have that 2-year green card, and that's what it's called. It's a conditional green card. It has conditions which have to be removed. I know that I'm repeating myself, but I just want to make sure you guys get it. So there are the other type of applicants that get this conditional green card are people who apply for entrepreneurship or the EB-5 visas, but that doesn't apply as much in this context. And for this group is more for the first kind, the ones that went through the marriage process and they got their AP and filed it and then got approved. So anyone who has a 2-year green card, you want to make sure you know this. You have to remove the conditions. When do you file for removal of conditions? So I keep repeating myself as to the year, 9 months approximately, because you have to apply or file your 751 packet, because it's a whole packet, 90 days before your green card expires. So it's not 90 days after. It's like, if you want to do the math yourself, look at your expiration date on the green card and think 90 days prior to that, and that's your window. That's the window by which you have to file this 751. Do not wait. Do not, let it linger, because you'll get in a lot of trouble if you don't file within that window. Unless obviously there are extraordinary circumstances why you can't file. But if you don't want to do the math, you can also log into the filing date calculator that's on USCIS website. That's the link. So you can go there, input your expiration date, and it'll tell you, when you have to file by. So the deadline by which you have to file. And you cannot miss that deadline. Okay. And if you do, I'll tell you what's going to happen. So what happens if you don't file the I-751, within that window? You have to have good cause. Means you just have to have a really good reason why you didn't file within that window. And when you file your packet, your late packet at this point, you have to write an affidavit and explain, I didn't file because, X, Y, and Z. And the reason has to be really good, because, USCIS does have discretion. As you guys know, they have a lot of discretion, and they will be the ones determining whether that good cause or the reasons that you say you couldn't file are good enough to suffice that good cause. And so If they believe that it's not, it doesn't suffice that good cause, then they will deny your 751. You will not get the removal of those conditions, and then you become removable, which means they can then forward your case to EOIR or to immigration court, and you don't want to do that because then you open a whole can of worms, and it's going to get lengthy. You're not going to want to do it. It's that the immigration court has a backlog. So you just want to make sure that if you have a case where your marriage is real, you have the proofs, just file it and get it over with, and you'll be fine. A lot of the times, these type of processes are taking anywhere between like 9 months to a year, maybe if the backlog continues a little more, but you have to make sure that you file it. I heard from Natalie yesterday that she has seen that people were able to naturalize before their I-751 even got approved, or that both were adjudicated at the same time. So it does take a while, but at that point, that's not your problem. As long as you file it, let it let it get processed. But what happens if you don't file at all? Um, yeah, you don't want to do that. That's not a good idea. I don't recommend that you do that. I know that it happens sometimes. People forget, people don't calendar it. If you're someone that, you got your green card and then that's it, you don't even know, you don't hear about this, you have to make sure you do your due diligence, do your homework, make sure that if you have questions about why your green card is expired 2 years, or if you have a complicated case, make sure you go to an attorney immediately and like try to figure out what you can do. But try to file, try to get it in. If you do not file, these are some of the repercussions, right? Obviously, you would lose your LPR status, and then you become removable. You become removable. Uh, they will once you're deemed removable, they will forward your case again to immigration court, and then you'll get a letter in the mail that tells you your case, your conditions or failed to be removed or whatever, and then you'll get an NTA, which is a notice to appear before the immigration court, and then you have a hearing. And then once you're in the immigration court, then the burden of proof is on you, which means that you have to prove why you have to stay. You know, um, so you have to be careful with that. Just know that if for any reason you don't get this in, um, it doesn't matter how late you file, just submit and submit your reasons like I had mentioned it in the previous slide. So just, I wouldn't recommend not filing it. As far as evidence, again, this applies to people who have done their AP, got their legal entry, got their adjustment, and got their 2-year cards. You can do this on your own. I know a lot of people that have done their removal of conditions on their own. Uh, just to reiterate for Maddie, 751 is those it's a removal of conditions for people who have the 2-year green cards, people who got their approval for their adjustments before they were married for 2 years with the spouse that petitioned for them. Okay, so if you got that kind of green card, this is what we're talking about today. But so if you have a straightaway case, you can definitely submit this on your own. Just make sure your packages look good. You have as much information regarding your bona fide marriage so that your marriage is like real and it's deemed bona fide and it's not, considered fraudulent or what USCIS would see as kind of sketchy, or like there's like different things that would put up red flags for them to deem that your marriage is not bona fide. But you want your package to look as complete as possible. You're basically going to submit the same evidence as you did the first time with regards to making sure that they believe that your marriage is real. That includes, supporting documents, your if you have children, obviously birth certificates, or if you've had children in the time that has passed, and you send the birth certificates, pictures, bills, leases, um, as much as you can, tax records, if you bought a house, the deed, It doesn't matter if it's under just one name, but if you send a deed and you live in like 123, whatever street, and you have other bills, and the deed is under your spouse's name, but all your other bills show that you guys live together and cohabitate, anything that you can get to prove that, you should add it to your packet. And so you have to just make sure that you have enough proof, because you have to prove the entire year. So the year, 9 months. So always suggest, if you send tax records that cover a whole year, um, then you can send like bills for each year, a statement for each year, or for each month, excuse me. But for each month, you send bills or statements, or pictures with timestamps, social media posts. You can do text messages. I've had people translate text messages that have been very interesting. But we add them to the 751, because it just shows that there's a relationship, that there's a real marriage. So anything that can make your packet look good, you want to submit it with your application. The application is not long, is 11 pages. It's fairly simple. The instructions are pretty clear. And again, if you feel you have a straightforward case, you haven't gotten in trouble, since you've been married, and since you became a green card holder, you haven't been in trouble, you don't have any criminal record, you haven't had any encounter with law enforcement, you can do it on your own. It's pretty much just, again, the form, the pictures, and all the proofs, and you can submit that. If you have had a criminal record, I mean, you could try to submit, but I always suggest that you talk to an attorney. I want to make sure that I mention that, or a knowledgeable attorney at the very least. You want to talk to them if you have a criminal, because they're going to review your dispositions. They're going to review what exactly you were charged with, how everything was disposed of, and if it's something minor, they will explain. You have to send within the affidavit, explain what happened and all that. So it is doable for you if you do have so somewhat complex case, but I wouldn't do it if I don't talk to a knowledgeable attorney, because you don't want to mess this one up. You want to get those conditions removed and then have your 10-year green card and then go on to your citizenship. And that's another thing, is that if you have a criminal record, the attorneys are going to explain to you that that's going to affect your good moral character once you want to become a citizen. So it's good to kind of run that by an attorney, a trusted attorney, a knowledgeable attorney. Again, I repeat, a good attorney. But you want to do that. And so once you do that, um, you can go ahead and submit. So again, this is just like the evidence, pretty much what I just said. The identity document, obviously you have to send your green card, like always, same thing, your green card back and forth, and the evidence of your relationship. It could be anything. I repeat, it could be literally anything. And then there's additional proofs for people that are in the military or and have been stationed in another country, but those are, again, very specific cases. For the most part, the people that I'm talking about that have done AP and have now been here with their 2-year green cards, it's pretty straightforward. Um, so the fees also, right now, as it stands, without them raising it just yet, it's still $595 and $85 for biometrics. Now we have to file them separately because they said so. So, you file those fees there with the separate money orders. And if you don't have the fee, you could apply for a fee waiver. So you can send a waiver to see if you can waive the fees. That's why if you don't file and you say, oh, I didn't file because I didn't have the money, they could come back and be like, well, there's a fee waiver that you could have submitted and therefore doesn't meet the good cause. So you have to be careful with that. If you don't have the money and you can't come up with it and you can prove, that you don't have the income, to pay for the fees, then you can go ahead and file a fee waiver. And yeah, like always, I just put the link for the fee calculator because it's easy. If you don't know what to pay for some of the applications, just go on there and put in the information. And the fee changes. If you applied and got adjustment and you had a child that was derivative or that came in the application with you, the fees change too. So just be careful with that. Lastly, I wanted to talk about those who aren't with their spouse anymore. So if um, you're not with your spouse, it's still possible for you to file the 751. You don't absolutely need your spouse to file it if one of these applies. So if your spouse passed away within the time frame that you've been a green card holder, your spouse passed away, you have to send proof that he or she passed away, um, and then that some specific proofs, your identity documents and all that. If you got a divorce or an annulment, you can also file for the 751. It raises the bar a little bit and it's a little harder because then you have to explain why you got a divorce on top of proving that you entered the marriage in good faith or that it was a real marriage. So you still need those proofs. You still need to prove that the marriage was real. But on top of that, you have to submit the divorce decree and all that good stuff. So, but it's possible. It's possible that it'll be approved. I've seen it happen. So you can file it without your spouse if you guys got divorced. Um, Another one is if you're a victim of if you've been battered or you've been subjected to extreme cruelty, and there's ways. I know that the definition of extreme cruelty is a little bit odd because it doesn't have to be like you were tortured, or when you hear extreme cruelty, you picture some of the worst things. But if you were with someone and you married in good faith and that person was like threatening you with your immigration status, telling you that they weren't going to help you get those conditions removed or continue the process or whatever the case might be, that's also a form of extreme cruelty. That's not normal, and so you might actually fall under this category, if that is your case. So we've seen that happen before, where you did enter in good faith. It was a real marriage. You went in with the best intention, but it became toxic and abusive, and you were battered. And you can't file a VAWA because you already have your lawful permanent residence. So this kind of takes the place of that VAWA, right? Um, and then the last one is children also that are derivatives and their parent is subjected to extreme cruelty, and they are too, can also file without the need of the spouse of the parent that petitioned for them. They can file a 751 for the removal of their conditions because children also get the conditional green card. And then, same thing if they've been battered or subjected to some extreme cruelty, so they could file too. But the last one is if your removal would cause extreme hardship, which is a high standard as well. If you would have to prove how that is possible, how that would your removal in the United States, like if they take you and deport you, would cause extreme hardship or would cause extreme hardship. Why? So all of these are reasons why you can file without a spouse, but the packages do have to have specific details pertaining to each thing, and there's elements to each one that you want to have. But it is possible, and if you have a case like this, then again, I would suggest that you meet with an attorney and tell them the proofs that you have, because sometimes if the abuse is verbal or psychological, there's things that you can do that can help you get the removal of conditions approved, but it has to be really, really specific. And let's see, some questions, Jose. Let's say I meet someone and live with them for a couple of years. Let's say I meet someone. Okay. I mean, again, you can, even though that, so like the question is, you're married and then your significant other, your spouse moves to another state for work, or family to take care of a family member because they're ill, or for, something that you can prove, yes, you can still do the removal of conditions and prove that bona fide relationship. You just have to have proof of it. So you still have to have bills together. You guys have to somehow prove that you guys are in communication. So if you guys are calling each other, if you guys are messaging each other, if there's proof as to, you're going to have to do an affidavit regardless of, like, you know um and explain, my spouse had to leave because the mother, the father, the uncle was sick. Here's the medical proof that that's why they left the home for a couple of weeks, a month, 2 months, whatever the case is. But and then your spouse will do an affidavit too and let them know, like, okay, I had to move because these were the circumstances, but we still have a home, we still have bills, we still have property together. So yeah, you can still prove that your marriage is still very much bona fide. I mean, that happens. People get sick. The life happens. So it is obviously going to need more proof, but yeah, you can definitely still take um, the conditions off. What if a U.S. child was sexually assaulted, but mom is? Oh, that's a U visa question. So yeah, um, they actually have had cases like that where the child is a U.S. citizen and they are a victim of a crime. Specifically, in this case, it's a sexual assault. But yes, the mom can apply for a U visa. Same process of a U visa. They have to get certification that they assisted in the investigation. So you will still prove all that, but the mother steps into the shoes of the victim, and so yeah, the mother can definitely apply for a U visa in that case. But you will need to get a certification from a certifying official saying that the mother assisted in the investigation, whether that means that she had the child go to any if they had to go to court, if when the investigators came in, the mother allowed the child to speak to law enforcement. If they were part of the witness advocacy unit talks and all that. So you still have to prove that they helped and assisted in the investigation somehow. So because remember, with the U visa, you have to get a certified official signature first before you can file for a U visa. Gabriela, how long does it take to get approved? The removal of conditions. Um, I know it's you have so the 90-day window is when you submit it, when you have to submit by, but the actual process can take up to a year, really, again, because USCIS, they can have backlogs. So depending on the officer. Um, so you can send it and it could still be pending, and you can get to the point where you can file for a US citizen, and you can, send those concurrently. So to, like, they can be processing at the same time, and you can get approval for both, or get the removal of conditions first, and then you would get the adjudication of the citizenship. So yeah, it could take up to a year. I mean, so I've seen cases fairly quickly, 8-9 months. So it depends, but right now, what the I think the website shows is, I think, 24 months, but it's it's just some offices take longer than others, as we know. So but regardless of how long it takes, just make sure you file within that 90-day window. Don't don't let that pass. So even if you're waiting, it doesn't matter, as long as it's done. You get an extension anyway on the green card while it's processing. So even if it expires, um, you have an extension. You have yeah, that kind of that qualifies you. Once it's processing, it qualifies for an extension of your status. So you'll be okay. So I think that's the answer that Gabriela was asking. Do they get an extension? Yes, they do. They get an extension while it's being processed, and obviously you get that extension once you file. Um, you get your first receipt. It comes with the extension notice. Okay, so you'll be okay as long as you get it in. You're good. Um, yeah. So I think that's it. I don't know if anybody else has any more questions. I know I threw a lot at you guys, and I'm sure that that Vanessa and the team is going to share the presentation with you all. You can always share it with anyone that you think might benefit from this removal of conditions talk, because it's important. I want to reiterate and just repeat myself a million times that it is very important that anyone with a 2-year green card plans for the removal of conditions, keeps their proofs together throughout the year that they are with their spouse, because once that 90-day window comes, all they have to do is put in a cover letter, throw in their proofs, finish up the 751 form, which is not that long, and I'm telling you, it's not that complicated. If you follow the instructions, you'll be okay. If your case is straightforward, you can go ahead and make that packet yourself. I will be sharing some cover letters with the team, and maybe we could post them on the AOS group for anyone that wants to use them. But pretty much just make sure that you have a little folder going once you got your green card, and even if it's 2-year green card, have a little folder, and then just put in any proofs that you think make sense to add to your removal of conditions packet. Then that way, come your window, then you're good. Um, yeah, so 90 days. So look at your expiration date and then count 90 days before that, and that's your window to file. So yeah, about 3 months. Yeah, before your green card expires. So yeah. So just make sure that you have your proofs together, and that way, within as soon as I've had people that literally to the day, the 90 days before, boom, they've already have their proofs, and they're ready to file, because most of us that are filing that have DACA, and I know that there's a lot of couples. What I see is very common too in our group is the fact that that we've been together um, with our parejas, our spouses, way before we got married. We could be with them for 10 years, but only been married, a little bit of time. And then we file for adjustment. And it feels like, well, I've been married forever with them. But really, legally, we haven't. And so that's why we get a conditional green card. I've had clients question, like, why did I get a 2-year green card? And we've been together for so long, and I sent proofs that we've been together for 10 years or more, or we've been high school sweethearts. But they don't go by that. They go by the date that you got approved. And if you weren't even at the 2-year mark, then you get a conditional green card. No ifs, ands, or buts. So, it sucks because some people have been together really long, but unfortunately they married, um, more recently, specifically like those of you guys who did AP. I know people that do AP and then they get married and then they file for adjustment, or they got married, did AP, but they haven't been married for 2 years by the time that you know the AOS gets granted. So um, they'll get conditional green cards. So that's why this is important. But I was really happy to be here with you guys. I hope that you guys got something out of this. I'll be around. You'll see me in the comments somewhere. You guys feel free to reach out to the team if you want more information. I can always come on and explain things more, and like if you guys want specific details on some of the other categories on that we spoke towards the end of the presentation, I can do that too. No private messages to anyone in the group, because Vanessa will have your head. And so let's not do that. But thank you guys for being with me. I hope you guys enjoyed it. I'll be around. I hope. Oh, we got one last question. Hold on. Does the evidence has to be from the time of marriage to present time? The evidence has to be from the time you got your green card approval to present time, to the time that you're filing your 751. So you don't have to go all the way back to the beginning because you've already submitted for that. It's from when your green card got approved to present time. So just right after you got your green card, up until you have to file the 751. So yeah. But okay. Thank you guys. Have a great night, day, evening. I don't know what time it is. But I'll see you guys around. Bye.